Charles Chevelle.
Thank you, Mr Speaker. Mr Speaker, members on this side have been pleased to support the bill through all its stages in the Parliament because we think it is a good one. It's reflective in particular, as has been noted, of the very hard work of the previous Labor government, and in particular on the part of my colleague, the Honourable Leanne Dalzell, who was Minister at the time the agreement which the legislation is based on was reached. But, Sir, it is interesting to have a look at the question of what legislation that benefits business truly is. It's actually, as far as this government's record's concerned, simply the reenactment so far, or the continuation of the enactment of legislation largely originated by Leanne Dalzell, either when she was Minister of Justice or Minister of Commerce, that has constituted all of this government's meaningful pro-business law reform agenda. So it's significant to note that that's actually the case. For all the rhetoric, for all the dog whistle about laws around extending the fire at will period to all businesses, all this sort of legislation that actually won't make a difference to business in reality, the substantive reform program, the pro-business law reform program, is a continuation of the work of my colleague, and I want to put that on the record of the House fairly and squarely. The other matter that I want to refer to right up front is the inappropriateness, sir, of having this legislation go through the House under urgency. There's no justification whatsoever for doing this, although there is multi-party agreement on the appropriateness of the legislation and the importance of the legislation, and certainly members on this side are pleased to see the legislation finally being progressed. The procedure adopted here is an embarrassment. We had the Minister in the chair. This job was foisted on him clearly. He didn't know the answers to questions around what the government's program to extend the legislation through Clause 51, advising the Governor-General to give or classify certain tribunals and courts in Australia. He simply didn't know the answers to the significant questions that the House should have heard answers to in the record. And I don't blame the Minister for that. The Minister did a good job in the circumstances. Although he did have the officials present, he might have actually asked them a couple of questions so that he could have enlightened the House around just what the government intends by way of extending further the scope of the bill as the legislation allows, and which would clearly be a good thing. That's what happens when you rush legislation through under urgency, when you don't have the responsible minister available to sit in the chair, and when you have two substitute ministers during the committee stages. They're simply not in a position to address the important questions. I would have hoped on a measure as important as this, and particularly with a minister who claims to be as pro-business as the minister who gave the third reading speech in the House today, that we might have seen a slightly more respectful process for this House, but that is, unfortunately, under this government, a vain hope. Mr Speaker, it is good that, and that was an interesting interjection from a member opposite, not known for his humility, let it be said. But, Mr Speaker, it is true that it is a good thing that this bill will allow a broader range of judgments to be registered and enforced between Australia and New Zealand. It will allow court appearances by video link between the two countries, and it will allow the enforcement of regulatory regimes supporting Trans-Tasman markets. All of this will make the doing of business and the resolution of disputes across the Tasman far simpler and more affordable. So when I was working in the Sydney office of my old law firm, one of the constant frustrations for businesses and individuals doing business across the Tasman was that they had this integrated single economic market. It was going along apace. People were very much in favour of it, but suddenly when there was a legal dispute incurred between, say, South Australia and New Zealand, there was no effective way of enforcing the judgment unless there was a dispute that could be resolved in the Federal Court of Australia on the one hand and the High Court of New Zealand on the other. Then there was a reciprocal enforcement procedure thanks to the work done by Geoffrey Palmer back in, I think, 1989, 1990, when there were amendments to the High Court rules and the rules of court in the Federal Court itself. So if you were lucky enough to have a dispute in the Federal Court on a federal matter in Australia, and you could then basically achieve some sort of mutual enforcement. But if it was a state court, if it was any other court in the federal regime, you were essentially prejudiced. So we are fixing that finally. That is a desirable outcome, and that is why Labor substantially supports the bill. But I think on the issue of economic catch-up with Australia, which is a mantra we hear a lot from in this House and outside it these days, then really what we do need is more of this sort of legislation to fix the sort of real productivity issues that occur as roadblocks between Trans-Tasman business. And as I say, I'd like to see more of this sort of substantive reform, the sort of reform that was well thought through and evidence-based and advanced so strongly by Leanne Dalzell and Michael Cullen in the last government, rather than dog whistle slogans around increasing productivity and trying to catch up with Australia, which is unfortunately the record so far of members opposite. I just want to give an example of how the measures in this legislation are positive. If there's an Australian-based company offering investment schemes to New Zealanders, they're registered as an overseas company in New Zealand, they've got somebody appointed to handle their legal proceedings here, they make a misleading statement in one of their documents, this company is prosecuted under the Securities Act, resulting in the imposition of a fine by the court. Well, under the current system, because S might have withdrawn all its assets from New Zealand and moved them back to Australia just to evade enforcement, it's just not going to be possible to enforce any fine. This is a waste of legal costs for all involved, and in fact people don't even bother with legal action in these circumstances. And there's no accountability under the laws of New Zealand, which has a detrimental effect on respect for the legal system. So under the legislation proposed in this bill, our Securities Act would be able to be more enforceable in Australia. The fine would be just as enforceable against the company there as it would have been if a civil judgment had been made in a New Zealand court. That's got to be a good thing, and it's something that certainly ought to be supported across the House. At the moment, as I've said, only final money judgments can be enforced on a Trans-Tasman basis. There's no ability to get interim relief. The decisions of the tribunals of one country can't be enforced in the other, and even though the Minister couldn't tell us which tribunals will be referred to by the Governor-General in extending legislation, we can assume that there will be such tribunals. The rules to determine which country's courts will decide a matter are confusing, and neither civil pecuniary fines nor criminal fines can be enforced in a country other than the one that they were imposed in. These are the sorts of barriers that really exist to productivity. These are the sort of problems that ought to be addressed. But instead, what we see this government largely doing is trying to remove the rights of people to fairness at work. They say that that's the way to achieve better productivity across the Tasman. Well, sir, we know that's nonsense. We know that the way to get proper productivity and proper business law reform to the benefit of our nation through is to advance bills like this. It's just a shame that this one's being done through urgency without the responsible minister present to tell us the answers to some important questions. Leanne Dalzell's posed them. I've tried to pose some of them. We haven't heard answers, so we're not in the best space possible. But nonetheless, the bill is finally going through, and that is something that we should be pleased about.